Before anything else, if you are in immediate danger, call 911. If you need support or want to talk through your options, the National Domestic Violence Hotline is available at 1-800-799-7233, anytime, day or night. What follows is general information about a California court form, not a substitute for that kind of help. A plain language, section-by-section walkthrough of California Form DV-120, the response filed by the restrained person in a domestic violence restraining order case, including deadlines, what to write, and what is at stake at the hearing. What is Form DV-120? Form DV-120 is the California Judicial Council form filed by the person who has been asked to be restrained in a domestic violence restraining order, DVRO case, generally called the responding party. It is the counterpart to Form DV-100, the request filed by the person asking for protection. DV-120 gives the responding party a formal way to state whether they agree or disagree with each of the orders requested, respond to the specific incidents and claims described in the DV-100, explain their own version of events, ask the court to deny the requested orders or to grant more limited or different terms instead. There is no filing fee to respond to a domestic violence restraining order request in California. Who files a DV-120 response? DV-120 is filed by the person named as the restrained party in a DV-100 request once they have been served with that request and any temporary restraining order. If you were served with paperwork asking a court to restrain you from contacting someone, DV-120 is generally the form you would use to respond. If you are unsure whether the papers you received are a DV-100 request or whether a response is the right next step for your situation, a court self-help center can help you confirm what you have been served with before you proceed. Filing and serving DV-120 before the hearing. Timing matters a great deal with DV-120. In general, once served with a DV-100 request and any temporary restraining order, you are also given notice of the hearing date, where a judge will decide whether to grant a longer-term restraining order. Filing your DV-120 with the court clerk and then having it served on the other party before the hearing puts your position in front of the judge in writing ahead of time. Courts generally expect a response to be filed and served with enough time before the hearing for the other party to see it, so waiting until the last moment can limit how much the judge is able to consider. Agreeing or disagreeing with the requested orders. A central part of DV-120 is telling the court, order by order, whether you agree or disagree with what was requested on the DV-100. The requested orders generally fall into a few categories: personal conduct orders, no contact, no harassment, stay-away orders from home, work, school, move-out orders, and temporary custody, visitation, and child support. You do not have to agree or disagree with every order in the same way. It is common to agree with some requests, for example, staying away from a workplace, while disagreeing with others, for example, a request affecting custody time with shared children. Responding to the claims and explaining your side. DV-120 also gives you room to respond directly to the incidents described in the DV-100 and to explain your own version of events. This is often the part of the form that takes the most thought. When completing this section, it generally helps to responding to the specific incidents described in the request, rather than only offering a general denial, including dates, locations, and other people present, where you remember them, explaining any context you believe the court should know, in your own words, attaching additional pages if you need more space, following the court's formatting rules. Judges generally weigh specific, detailed accounts more heavily than general statements. Asking the court not to make the orders or to make different ones. DV-120 also lets you ask the court for a different outcome than what was requested. Depending on your situation, this can include asking the court to deny the requested restraining order entirely, grant more limited orders than requested, such as peaceful contact only for exchanging shared children, set different stay-away distances or locations than what was requested, order a different custody or visitation arrangement than what the other party proposed. If your case involves shared children, Our guide on California child custody laws. Explained covers how custody and visitation are generally decided in family court, which can run alongside a DVRO case. What happens at the restraining order hearing? The hearing is where a judge decides whether to grant a restraining order after hearing from both sides, and if so, on what terms. In general, at the hearing, both the requesting party and the responding party have the opportunity to speak and present evidence. The judge considers the DV-100 request, any DV-120 response that was filed, and whatever is said or presented at the hearing itself. The judge decides whether to issue a longer-term restraining order, which can last for a period of years and can later be renewed. If issued, the order can include personal conduct, stay away, move out, and custody or support terms. Custody, firearms, and housing. What is at stake? A domestic violence restraining order case is not only about contact between two people. The outcome at the hearing can carry consequences that extend well beyond the order itself. Child custody and visitation, since a restraining order can shape temporary and long-term parenting arrangements. Firearms rights, since California law generally prohibits a person subject to certain restraining orders from owning or possessing firearms while the order is in effect. Housing, since a move-out order can require the restrained person to leave a shared home. Future proceedings, since a restraining order can be referenced in later custody, support, or family court matters. Common mistakes to avoid: missing the deadline to file and serve DV-120 before the hearing, giving only a general denial instead of responding to the specific incidents described, failing to address every requested order, leaving the court without your position on some of them, not requesting the specific alternative terms you actually want, such as modified custody or contact arrangements, skipping a conversation with a self-help center or attorney given what can be decided at the hearing, arriving at the hearing without organized copies of the DV-120 and any supporting evidence. If keeping track of all of this by hand feels like a lot, that is exactly what Virdix is built for. The wizard at Virdix.co walks you through these same questions in plain language and prepares your DV-120 for you. Virdix is a document preparation service, not a law firm, so this is not legal advice, but it can help make sure your paperwork is complete and consistent from the start.